People from all walks of life have utilized Chapter 13 of the Federal Bankruptcy Code to help them in times of financial difficulty. Chapter 13 is a legal method for people to obtain economic relief from their debts while at the same time providing a fair means of repaying their creditors. This program has been designed to inform you, as a debtor, of your responsibilities and obligations while voluntarily participating in Chapter 13. This video will answer most of your questions. However, if you have a question that has not been addressed in this presentation, a representative of the trustee's office will be available to answer your questions at the end of this program. Everyone filing Chapter 13 has been given a book. This book contains information concerning your responsibilities and obligations. You will need to read this book and store it in a safe place for future reference. The front cover contains a case number that was assigned to your case by the bankruptcy clerk. If you send the trustee any type of correspondence, such as a letter, a payment, or a note, please include your case number. The trustee handles thousands of cases each month. Without your case number, your correspondence could get lost. Your book also contains the address and phone number of the trustee's office. All correspondence should be sent to this address. If you need an immediate answer to a question, you can phone the trustee's office and discuss the matter. The trustee cannot give you legal advice. That is the responsibility of your lawyer. Your lawyer represents you throughout Chapter 13. Your lawyer's name, address, and phone number is listed on the front cover of your Chapter 13 book. It is important that the court notify all your creditors of your Chapter 13 so they can participate in the case and leave you alone. One of the primary advantages of Chapter 13 is the automatic stay. The automatic stay is a law that prevents your creditors from coming after you for payment of a debt. Your creditors cannot phone you, garnish your wages, take your property, mail you notices, or pressure you into paying your debt. If a creditor tries to contact you or pressure you, notify your lawyer. Another advantage of Chapter 13 is that you have the opportunity to rewrite your contracts with your creditors in your plan. By rewriting your contracts, you can change monthly payments, alter interest rates, and adjust the length of your payments. Your plan can eliminate late charges, penalty charges, service charges, and in some cases, reduce the amount of your debt. You can do this so long as your plan treats your creditors fairly. You have 3 obligations that are very important in Chapter 13. First, you have promised to pay the trustee on a regular basis for the duration of your plan. Second, you cannot borrow money. And third, the trustee's office must know your address at all times. Your first obligation is to pay the trustee. This is a personal commitment that is part of your plan. The court has instructed your employer to deduct money from your paycheck each payday. Now, most of you have already seen how this works. If you receive a paycheck and your payroll deduction has not been made, you must notify your lawyer. You are still responsible for payment to the trustee, even if you have to obtain a money order or a cashier's check. The trustee's office cannot accept cash or a personal check for making a payment. If you do send in a money order or cashier's check, make certain that you put your case number on the front. Remember, it is your responsibility and personal commitment that payments must be made to the trustee. Even though you were required to pay into your plan, the trustee is not like one of your creditors. The trustee will not phone you or send you notices if you miss a payment. If payments are not made, the trustee will go to the bankruptcy court and ask the judge to dismiss your case. Your creditors will then be free to come after you, to garnish your wages, take your property, charge you finance charges, late charges, and penalty charges. If your case is dismissed, you are in the same position you were in before you filed Chapter 13. Make sure that you notify your lawyer of anything that will affect your payments. If you lose your job, get laid off, get sick, and cannot work, or change jobs, contact your lawyer as soon as possible. Your lawyer is in the best position to give you advice as to how this may affect your plan. Your trustee has no authority to allow you to miss a payment. The only person that can let you miss a payment is the bankruptcy judge, and the only way to contact the judge is through your lawyer. Your second obligation under Chapter 13 is that you cannot borrow money. For example, you can't go to a bank, a credit union, savings and loan, or finance company and borrow money. You can't buy anything over time or run up a tab with anybody. You are also prohibited from using a credit card. However, there are exceptions. The judge will allow you to incur a debt for medical emergencies, such as a doctor's visit, dental appointments, prescription drugs, hospital, or clinical care. There may be a situation when you have to borrow money. For example, your car breaks down and has to be repaired. Before committing to time payments, discuss the problem with your lawyer so that you can ask permission from the judge. If you've been faithful to your Chapter 13 payments and can afford it, the judge will usually allow you to borrow money for a good reason. Remember, you have to obtain permission from the judge to borrow money, or you risk having your case dismissed. Your third obligation is critical. It is your responsibility to make certain that the trustee's office has your correct mailing address at all times. While you are in Chapter 13, the trustee's office will mail you information concerning your case. If you move across the street to another side of town, to a different city, or even out of state, notify your lawyer. The bankruptcy court and the Chapter 13 trustee's office. You are involved in an active, ongoing federal court case, and it is very important that the trustee's office can reach you at all times. You are protected from your creditors by the automatic stay. They cannot pressure you while you're participating in Chapter 13. You, in return, should not go out and make payments to individual creditors. Trying to pay one creditor over another is not fair to all your creditors. While in Chapter 13, you have pledged to treat all creditors fairly. Within your plan, you have already decided how you will repay your creditors. Through payroll deductions, money will be paid to the trustee. The trustee will then disperse those funds to your creditors. If you pay one of your creditors yourself, you may actually be paying that creditor twice, once by you and once by the trustee. There may be a time when you receive extra money from a pay raise, a second job, or a tax refund. If you ever have extra money and you wish to pay your creditors, send the money to the trustee's office. The more money that you apply to your case, the quicker you will finish the plan. When you contacted your lawyer to represent you in Chapter 13, your lawyer asked for a complete list of everyone to whom you owe money and the amount. This list is very important. It was used to notify your creditors that they have 90 days to file a claim in your case. If a creditor fails to file a claim within 90 days, he may forfeit the right to get paid. When you finish your Chapter 13 plan, you will no longer be obligated to pay most of those debts. After 4 to 5 months, you will receive a list of all creditors who filed claims in your case. It is important that you check the list very closely. The time to do this is when the list comes out, not several months later. If you notice someone on the list to whom you do not owe money, call your lawyer. If you notice a creditor claiming that you owe more money than you do, call your lawyer. Unless your lawyer objects to these claims, the trustee will pay those creditors the amount that they ask for with your money. Your lawyer and the trustee can only estimate how long your case may last. Your case will last until you pay what you promised to pay your creditors. Only when you reach this level will you be finished with your Chapter 13. During Chapter 13, you may want to know your status. How much longer do you have to stay in Chapter 13? What is your payoff balance? Did the trustee receive your payment this month? How much money was paid to your creditors? If you would like more information about your case, you can obtain this information from the trustee's website, or you can write the trustee. Make certain that you know your case number and your current mailing address. In order to complete your Chapter 13 case, you must attend an approved course on financial management. While you can choose to attend any course approved by the Department of Justice, the trustee offers such a course without additional cost to you. To make a reservation to attend the trustee's course, call the trustee or log on to the trustee's website. You have been given a lot of information during this presentation. The next portion of this program will summarize your obligations and responsibilities while participating in Chapter 13. Chapter 13 Bankruptcy is designed to help you with your creditors. The book that you were given contains important information about Chapter 13. Take the time to read this book and store it in a safe place for future reference. Your case number is located on the front of your book. Always use this number when corresponding with the trustee's office. You have several important obligations under Chapter 13. First, you must pay the trustee the money you have committed to. Second, you cannot borrow money while in Chapter 13. Third, you must inform the trustee of your current address at all times. Remember, your lawyer represents you. If you have a question concerning Chapter 13, contact your lawyer. You must list all the creditors in Chapter 13. You must be fair with your creditors. Do not try to pay them yourself. If you wish to make an advance payment, pay the trustee. The trustee will send you a list of everyone that has filed a claim in your case. Check the list closely. If you notice a creditor claiming that you owe more money than you should, contact your lawyer. You must attend an approved course on personal financial management. Make arrangements to do that now. These guidelines and responsibilities are part of Chapter 13. It is very important that you follow them. If you have any questions concerning Chapter 13, contact your lawyer and notify your lawyer of anything that will affect your payments.
I am George Payne, the Chief Judge for the United States Bankruptcy Court for the Middle District of Tennessee. You are required to watch this program as part of your Chapter 13 bankruptcy case. If you listen carefully, you will not be required to return to court to attend a discharge hearing when you have completed making the payments under your plan. Watching and listening to this program is one of your responsibilities as a debtor in Chapter 13. I have the responsibility of explaining certain things to you about your Chapter 13 case. First, I'm going to tell you what it means to receive a discharge in a Chapter 13 bankruptcy. Secondly, I'm going to tell you the kinds of debts that are accepted from that are not discharged in bankruptcy in a Chapter 13 case. To obtain a discharge, you must do three things. First, you must complete all your payments to the trustee. Second, you must certify that any domestic support obligation that came due during your case has been paid or that you have no domestic support obligations. Third, you must attend an approved course in personal financial management. After you have completed your Chapter 13 plan, after you have finished making all the payments that you have promised to make in your Chapter 13 plan, after you have filed your certification that you have made all your domestic support payments, and you have submitted your certificate of attendance at an approved course in personal financial management, you will receive a discharge order. That may be several years from now, maybe 3, 4, or even 5 years from now. The actual order, the discharge order itself, will be sent to you in the mail several weeks after you have completed all of your payments and made your certifications. That discharge order, when you get it at the end of your payments under your plan, is an important paper, and you should put it where you store your important papers. First now, let me tell you what it means to get a discharge in a Chapter 13 case. Discharge means that the debts you listed in the schedules that you have filed with the bankruptcy court are no longer your personal obligations. They will no longer be able to be collected from you personally. If you finish making the payments under your Chapter 13 plan, pay any domestic support obligations, and attend an approved course in personal financial management, the creditors you listed on those schedules the ones you filed with the bankruptcy court, will not be allowed to demand payments from you. They will not be able to bring lawsuits against you. They cannot take judgments against you. They cannot garnish your wages or repossess any property from you. If you are ever contacted by a creditor that you listed in the Chapter 13 schedules in any way, by phone or by mail, by computer, by the filing of a lawsuit, or in any manner whatsoever, as part of an effort to collect one of those debts from you, and that means now while you're in your bankruptcy case or after you finish making payments and receive your discharge, it is important to you and it is important to the integrity of the whole bankruptcy system that you contact your attorney immediately. As a general rule, your lawyer can fix that problem at no cost to you. Now, there are some debts that will not be discharged at the end of your Chapter 13 plan. Even though you complete payments under your plan, file your certificate on support, and attend a course in personal financial management, these are debts that will still be your personal obligation and can still be collected from you after your Chapter 13 is finished and after you have received your discharge order, unless they were paid in full during your Chapter 13 plan. Because this is the beginning of your plan, and you have a case pending, and you have a lawyer, now is the easiest time and the least expensive time for you to deal with the creditors whose debts are not going to be discharged when you finish payments under your Chapter 13 plan. Talk to your lawyer now about how you are going to deal with the non-dischargeable debts in the future. I want to describe the most common debts that are not discharged in a Chapter 13 case. The first kind of debt that is not discharged in a Chapter 13 case is a debt for alimony or child support. While you are in your Chapter 13 plan, you can provide for the payment of alimony or child support through your Chapter 13 plan. If you owe alimony or support, and when your plan is finished, you still have to make payments on that alimony or child support claim. It is not going to be discharged at the end of your plan. The second kind of debt that is not discharged in a Chapter 13 case is a long-term debt, a debt that is intended to last longer than your plan. For example, a home mortgage or a mobile home where the term of the debt is longer than the payments you are going to make under your Chapter 13 plan. A debt like that is not discharged in bankruptcy, and when you finish your Chapter 13 plan, you will still have to finish making payments on that long-term debt. The third kind of debt that cannot be discharged is a debt for injuries or fines incurred while operating a motor vehicle under the influence of drugs or alcohol. A DUI obligation cannot be discharged in a Chapter 13 case. The fourth kind of debt that is not discharged in a Chapter 13 is a student loan. Student loans are non-dischargeable in a Chapter 13 case. While a student loan creditor cannot collect the debt while you are in a Chapter 13 case, you will be responsible for any amounts that remain due after the case is closed. Also, if you have been convicted of a crime and as part of that conviction you have been ordered to pay restitution, the restitution claim is not dischargeable in a Chapter 13 case. If you have a judgment against you for deliberately injuring someone, that debt will not be discharged. If you fail to list a creditor on your schedules, your Chapter 13 plan is not going to discharge that debt. That means that it is especially important that if you have become aware of any debt that you forgot to tell your lawyer about before, tell your lawyer now so it can be added to your Chapter 13 case. Otherwise, it will not be discharged. If a creditor believes that the debt you owe them is based on fraud, embezzlement, or theft, or a willful injury to a person, they must file a bankruptcy lawsuit called an adversary proceeding. A creditor has 60 days after your meeting of creditors to file that kind of lawsuit. If such a lawsuit is filed and the court determines that the debt is one of those kinds of debts, that debt will also not be discharged. If you receive a copy of a lawsuit saying that you should not receive a discharge for this kind of debt, you should see your lawyer at once. If you do not object to the lawsuit, the court may very well decide that you agree with the creditor filing the lawsuit. Now, we want to make sure at this early stage in your Chapter 13 case that you understand all your rights and responsibilities. That means it is especially important right now that you ask any questions that you have of your lawyer so you can clear the problems up before they get worse. Many of you will be in a Chapter 13 case for several years, and you will have questions along the way about your Chapter 13 case and about the effect of the discharge. Please discuss those questions with your lawyer at this time. Thank you very much.